In this video, I'm going to discuss the landlord's duties in Washington State when a tenant dies. The most common questions when a tenant dies are: who may enter the unit? Who is responsible to remove personal property? Who pays the rent? How long before the landlord may reasonably expect to regain possession of the unit? One of the important definitions in the Landlord-Tenant Act defines a tenant representative. A tenant representative is a personal representative or PR of the tenant's estate, a person claiming to be the successor to the tenant's estate who has provided proof of death and an affidavit, a person designated using the procedures under the July 2015 Act, or any person who provides the landlord with reasonable evidence that he or she is a successor of the deceased tenant. Where the tenant is a sole occupant, the landlord may require the tenant to designate a tenant representative. A tenant representative will act for the tenant in the event the tenant dies. The designation must be in writing and separate from the rental agreement. The designation must include the designated person's name, mailing address, email address, and telephone number. A signed statement authorizing the landlord to allow the tenant representative to enter and remove the tenant's property, receive refunds, and follow the requests of the tenant's last will and testament. And a statement which must be conspicuous that the designation is in effect until revoked in writing or replaced with a new written designation. The tenant who is a sole occupant may make the designation without the landlord requiring it. The tenant may change or revoke a designation at any time as long as it's in writing. When a tenant dies who is a sole occupant of a rental unit, the landlord must promptly deliver written notification to the tenant representative and any other parties who are designated as next of kin in the rental application. The notice should be delivered to everyone by any means, email included, that may be a successor or representative of the deceased tenant. The notice must include name and address of the deceased tenant, approximate date of death, the monthly rent and the date through which rent is paid, a statement that the tenancy will terminate 15 days from the date of the notice, or on the date that rent runs out, whichever date is later, unless the tenant representative makes arrangements to pay rent for up to 60 days in order to allow the tenant representative to remove the tenant's personal property. A statement that if the property is not removed on time, the landlord will be allowed to enter the dwelling unit and take possession of any property, store it, and charge for the reasonable costs of moving and storage, and then sell the property after service of a second notice. A copy of the tenant's designation of a tenant representative. When a tenant dies, a landlord must give the tenant representative possession of the tenant's personal property if requested in writing. Any unearned rent and security deposit must either be refunded or accounted for in writing to the tenant representative. A tenant representative who removes property from the tenant's dwelling is required to provide to the landlord an inventory of the removed personal property and sign an acknowledgement that the tenant representative only has possession and not ownership of the property. Before selling or disposing of the tenant's personal property, the landlord must send a second written notice to the tenant representative. In addition, if the tenant representative paid rent, the second notice must state the name and contact information of the tenant representative, the amount of rent paid and the date through which the rent was paid, a statement that the landlord may sell or dispose of the property on the later date of when the date the rent runs out or 45 days from the notice, unless the tenant representative removes it himself. If the landlord stores the tenant's personal property, the landlord must send the tenant representative written notice that the landlord may sell or dispose of the personal property in 45 days or when the rent runs out, whichever date is later. The landlord must turn over possession of the personal property to the tenant representative upon written request and payment of the actual or reasonable cost of moving and storage of the property, and delivery of an inventory of the property and an acknowledgement that the tenant representative has possession and not ownership of the property. The landlord must, within 14 days of removal of the personal property, refund any unearned rent and provide a statement to the tenant representative for retaining any amount of the security deposit. If the tenant representative does not contact the landlord or remove the tenant's personal property, the landlord may sell or dispose of the tenant's personal property, except for personal photographs and personal papers. If the fair market value of the property is greater than $1,000, the property should be sold in a commercially reasonable manner and disposed of in a reasonable manner. If the value of the property is $1,000 or less, it may be disposed of in a reasonable manner. These terms are defined in the Residential Landlord-Tenant Act. When disposing of the tenant's personal property, neither the landlord nor anyone who works for the landlord may own or acquire the tenant's personal property. The landlord may, upon learning of the tenant's death, enter the unit, make arrangements for the tenant's pets, and dispose of food and garbage. Any notices by the landlord must include contact information for the recipient to contact the landlord. Violation of these laws make the landlord liable to the tenant's estate for damages, including costs and attorney fees. A landlord who complies with these laws has no liability relating to the deceased tenant's property. Consulting with an attorney prior to delivering notices can save you thousands of dollars in lost rent, litigation costs, and fines. It can also save you time and headaches. The Loeffler Law Group is familiar with landlord-tenant law and emphasizes landlord-tenant relations.